We are back in Senate Judiciary. It's April 3rd. We're talking about H98 and S95. It's without objection. It sounds like we're going to be combining those two bills. I don't believe there's any changes to the confirmatory adoption bill. Is H98. Ours get a few suggestions for amendments from Senator Norris and also a few zoning that we received over the week. So we will, we can just start with that. So, and Eric, do you have the, were you with us when Judge Zone was here making a few suggestions?
I wasn't here, but I was able to listen to some of the YouTube later on. So
okay.
I'm not sure that I got all of them, but I think I got the gist of most of them.
I took a few notes as well, but
yeah.
I think if we start from the beginning,
okay.
Senator Norris had did you want to discuss what your suggestion was?
Well, Eric, oh my gosh.
Oh wait, you want?
No, fine. Yeah, on page 4, you're starting with line 7. Where it clearly states arrest or apprehension by any local, state, or federal law enforcement officer for an alleged violation of a federal immigration law. I spoke to Jill along with Barbara, the other young lady, and explained in areas of the process that while local and state are not allowed to, nor do they enforce immigration law, and this specifically states immigration law. So my suggestion, and they were in agreement with it, and correct me if I'm wrong, Eric, was simply a strike through on the state and local law enforcement that we don't enforce immigration.
Yeah, I think that's exactly what everyone agreed to.
Yeah, so they were good with it.
Yeah.
That's it for me.
So just want to make sure that the interaction with 44. So on the immigration agreements, Eric, you know,
What we passed, the
Yeah.
247.
I think it was 44. That's 44.
Emergency declarations or whatever.
Yeah.
The prohibition on local agencies assisting federal immigration.
Right. Was that? I remember there was.
That's 44.
Yeah. If I can interject that, in my opinion, I think that's covered by the next section right below. It can be arrest, detention, or custody by DHS or a federal, state, or local agency authorized by or acting on behalf of DHS.
Okay, that was my question was. Right. So if we strike out local and state and it be as is, we would still be covering any agency that is through one of those agreements working with the federal.
Yes, I can't say that I'm familiar with the details of S44, but conceptually, from what you just said, yes, I think that's correct. That a state or local agency that is working with DHS would be covered by B.
Okay.
Eric,
What thought? Sorry, go ahead.
No, I was just going to say S44, what it does is, all it really says is that if a national state of emergency is declared, okay, local and state agencies can enter into an agreement, but first they have to get authorization from the governor. And prior to Act 44, they did not need to get authorization from the governor.
Right.
So it doesn't change the, I guess, the substance of the agreements. Technically, they could still enter into them, and if they did, and if they did, and they are, and let's say a local agency is in such an agreement, and there's an arrest that falls under the adverse immigration action, you would still fall.
Right. I think that's my read on it as well, based on that description of S44. Yeah, I think it makes sense that this wouldn't change that, and in fact, still includes that concept.
Yeah.
Yeah.
Okay. In that case, I have no objection to keep striking it through.
Well, we were considering.
And I did have one question / concern, which I don't know if there's a proposed change, but So I'm looking down the bottom of page 4, subsection F. The denial of admission or entry into the US by DHS or other local or state officer acting on behalf of DHS. And I think my concern is the interaction of our state laws, federal laws. If we are to say that the child, a family that has been denied entry can still be placed in a standby guardianship. You get what I'm saying?
The denial, I remember it had, when, Senator Norris and, I had that conversation, we were also talking about F a little bit, and, they were talking about the sort of hypothetical situation, at least one that they encountered with some regularity, that's meant to cover the idea, just as an example, like, for example, the one of the parent goes to Canada to work, right? That was the one they were describing. And then with the child, they reside in Swansea. And so kids are here, parent goes to Canada to work, can't come back in. And then you have the kids.
Yeah.
So the idea is to have the guardianship available in situations like that. So I think that's what it's intended to cover, that kind of situation. And then, so when you were describing, is that a little different?
If I can, tell me if I'm right. This, I think, presumes that the child is already in the US.
Correct.
And you're wondering if the child is entering with their family, does this kick in? I don't think it does kick in for people who have yet to, for children who have yet to make it into the US.
Yeah, denied entry. So
We couldn't be doing a guardianship for somebody who's still outside the US.
Right.
Yeah.
Right.
What if that child went to Canada with their parent, came back to the border to come back in, denied re-entry?
But we can't affect that. That's for mom. That's a felony.
But they have that guardianship in place, that standby guardianship, would that child then be allowed, to be able to go to school, whatever?
I don't think we can do anything at that.
No,
Only if somehow the feds change their mind and let the kid back in. If they did
Because
have,
we can't affect Canada. We can't affect the
Yeah.
federal government.
Yeah.
So.
Okay. Just wanted to make sure we clarify that. So, areas.
and there was, do you want to back up a page? Or you already covered that piece. On page 3, also, right before that, I noted, one of the ones I noted was that, I think Chuck Zone and the folks, from legal aid had agreed that subdivision B was unnecessary there. That's page 3, lines 4 to 9. So they were talking about the idea that, custodial parents, in guardianship cases, there isn't any need to specify about whether it's the one with sole custody or joint custody, that sort of thing, that's all covered in it. That's, I think, I don't know if you agree, just write that real motion.
I mean, I'm always for seeing the staff get clean.
Right.
Right.
Yeah.
So, Mr. Chair,
Yeah.
just a little confusion. So I have Bill as introduced. Bob has Bill as passed.
I have Bill as introduced.
That's 92.
95 didn't go anywhere, so it wouldn't be passed.
I have as passed, I have photo. So I have 95 and 98 folders mixed up
Well,
under somewhere.
Eric, borrowed mine. That must be the one that was.
Yeah.
As introduced.
It wouldn't be passed.
Yes, but I remember we got 2 different bills.
Right, SH98, that's the house.
Yeah, S 95 was a bill that I.
You got
Regulatory adoptions.
We're looking at S95.
right. Here's your one.
Thank you. The loaner, I got my loaner back in.
All right, everybody trade, we have one person to the left.
I got that section.
All right.
So we were just talking about striking 4 through 9, just because it's unnecessary.
It's not necessary, exactly. I think everyone agreed that it would tend to be more confusing since it's not necessary.
Any objections?
On the advice of council. Reply them from the chair.
Yeah, that's exactly.
Prefers.
Only. Dan, I do all the time.
We look to.
I think it's in my job description.
So I have a note on page 9. And subsection A1. In which Judge Zoe indicate that consent, the spelling out consent in this section was unnecessary.
Yes.
That's all I have. Yeah. Do you have, you refreshed?
Yep, that's that second sentence, again, everyone, I think, agreed to strike the sentence, starting on line 7, the start was the consent shall provide. And again, it was an unnecessary, same idea that it's not necessary, the way the entire statutory provision is set up. Is that the,
It's triggered.
it's triggered, exactly, it depends upon the adverse immigration action happening. And that's the way the procedure works. And they have to sign that consent form, they have to have reached the agreement, and that the paperwork is in place, and not until the adverse immigration happens.
So that was,
No, what page are we on? 11?
9.
9.
That's no, you voted.
So just to summarize again, it was essentially lines 7 through 9
Yep,
that was considered unnecessary.
unnecessary and more confusing than helpful, and also redundant. So.
Any objection to striking that?
No.
Then the next I see is line 18. The parties intend to create a standby guardianship, replacing the word intend with the word shall. Does that sound familiar? Well,
I thought I had written down that they were striking the word intend to create and then replacing them with are creating. But maybe there was 2 different testimonies. That's the one I got from Judge Zoe.
the parties are creating a stand.
Yeah.
It has the same effect as just saying the parties shall create.
Yes, yeah, same idea.
So replacing line 18 with that the parties are creating a standby guardianship. Next section that I have as a recommendation was on page 11. And
It was 45 days.
Yeah.
yeah, concerned about the 45
Yeah.
days and the proposal for replacing it with either good cause shown to go beyond the 45 days or being more broad and just saying the order shall be issued promptly. Are there any thoughts on this committee or area?
I think, politics, whatever, however, you feel like you want to, what language maybe you think is more encouraging of speed, whether it's a promptly or and extend 45 days for good cause shown, either certainly works.
So
Yeah. I think I would want to sort of be more explicit because I think different people may have different interpretations of what promptly means.
So do you want to do the with good cause?
I think that feels better to me. Just because it gives an explicit, like it has to in this time frame.
yeah, considering it's yeah. Yeah, I think adding for good cause shown, allowing the court to go beyond 45 days. And would that have to be written, but they have to issue a written opinion on that, just. Or just say it on the record.
I think they could on the record, yeah, from the bench, if the parties presented some evidence that, you know, in this particular case, they weren't gonna make the 45-day limit. Here's why, A, B, and C. I don't think there'd be a requirement that the court go written. They had to say, all right, based on what the parties just presented here in court, I'm gonna extend it for whatever, 14 days, more days or something.
That's fine. Maybe any further thoughts on that? No, back to that. So it sounds like we're supportive of adding that the order establishing guardianship from section 2628 of this title within 45 days after the complaint was filed, and adding a sentence saying that the issue, however you want to phrase it, Eric, but that it may be issued beyond the 45 days for good cause shown.
Yeah, yeah, I can work something like that in a different one.
Next suggestion I have is on page 14 regarding changes of status, reports to the custodial parent for their last known email address.
That's one of that be given to the attorney, right?
Yep.
Which I'm not, I mean, the next sentence is, and to the custodial parent's attorney at the attorney's last known address. I'm not sure what I'm missing.
Why is one last known email address for the attorney's last known address? Is that explicitly that the attorney has to be mailed?
I think if I remember correctly, that stemmed from the idea that that the custodial parent may not be in the country where the presumptive that the attorney is.
I see.
So that one might not have a regular mailing address that was known.
But wouldn't the court have the attorney's email address?
Yes, in fact, that you have to answer right into the court.
Is it? It seems like it would take a lot longer to mail it.
Well,
Yeah, that might be what he was saying. Right.
I mean, an attorney assigned to the court, they get, you know, whenever anything gets filed, you get a notification through the Odyssey web system saying notification of service. So, hold on, let me just reread this again.
I thought the judge's testimony was because if any other proceeding, it's always on the attorney to provide that notice to their client.
Yeah.
And the court doesn't do that.
Well, yeah.
I thought that's what the judge was getting after.
Yeah, but this is for the guardian to provide that information, not the court. So it wouldn't be the court having the burden of having to send out emails. It's saying that the guardian, so, you know, family's friend or relative, they shall provide notice of all changes and status reports to the custodial parent, their last known email address, and to the attorney at the attorney's last known address. So I don't see it as being something that the court is required to do. And also, if it's something that the court isn't required to do, the guardian has to do it. I don't know that the guardian would necessarily have to file it in Odyssey. And so the attorney may not necessarily receive it in their email.
The custodial parent's attorney wouldn't get notification of the standby guardianship is filed. Because wouldn't that be a attorney of record for the custodial parent?
I think they get noticed then.
Yeah.
This seems to be talking about later on. Like, what about when so it's granted, you got to stand by guardianship, you got the guardian, you got the guardian finds out about changes and other things subsequently. I think it seems to be requiring that the guardian then let the attorney and the parents, right?
Yeah, that's how I'm reading it. So what I'm reading this as is just delegating some responsibility to the guardian. I mean, like to assume that somebody becoming a guardian for their friend or relative kid is going to keep them updated, but I think that this is just putting it in statute saying that if you assume the standby guardianship, you are required to update both the parents and their attorney. Updates and changes. So. Yeah. Not quite sure what, if any, change needs to be made. So I guess we could. I don't know. What are additional thoughts? What were you saying again?
Well, I didn't know if the attorney of record would get that notification anyway.
Yeah.
Like even the update, all changes and status reports,
Yeah.
does the system spit out back to the attorney
So
of record?
whenever, so like, let's say a petition is filed and the court says, okay, there'll be a hearing in 20 days. The attorney receives that hearing and that's through the automated system, and it becomes the attorney's responsibility to send that to a client.
Yeah.
Once the attorney gets it. So
then what are the changes in the status reports? Do those also get kicked out to the attorney of record for the custodial?
yeah, like
That would as well.
I guess, I mean, you know, what is a change or a status report? I guess is the question. I mean,
And is that custodial parent's attorney in the court when these are going on? Or just the guardianship?
no, I mean, this is assuming that, I mean, in some or perhaps many of the situations, it's, you know, a parent has been detained,
Yeah.
kid is living with a friend or a relative, and so detained parent presumably isn't going to be in the court. It would be their attorney working with the detained parent and the prospective standby guardian and the kid. So
Would there ever be a case where the attorney that's the custodial parent's attorney be the same as the standby guardianship attorney? Yeah.
I think that, yeah. I think maybe I can just reach out to Judge Zone and just clarify a few things, Senator.
Yeah, I just have a problem with the ambiguity of the language. So the guardian shall provide notice of all changes and status reports. I don't understand why you need, it sounds like the guardian should provide all status reports. But of all changes, what does that mean? Like,
If the hearing starts 10 minutes late.
right, or does it mean changes in the child's location, or, you know what I mean? Like,
Yeah, I mean, I think maybe we could put something along the lines of the standby guardianship shall make reasonable efforts to keep the custodial parent informed, apprised of the status.
Yeah.
That's one suggestion, but
I think if we got rid of, shall provide, strike notice of all changes and just say, shall provide status reports for the custodial parent.
yeah,
Although that makes it sound like they're required. And this language seems like it's saying they don't have to do it unless something happens. I don't know, it's a little murky in terms of what these people are required to do and how detailed it has to be.
yeah.
Aren't the changes related to all the sections before it, like current address, child's health care, child's educational needs, contact with the child, and
But like the child's strengths, challenges, and any other areas of concern.
is that just to keep the custodial parent aware?
Generally updated.
Yeah, I mean, it all seems like a
Well, that's
convoluted legalese way of just saying, if you're a guardian, just keep the parent updated as to how the kid's doing,
Yeah.
pretty much.
And
With my, how I'm translating it. Sorry, Senator Torres.
Yeah, I got a question. So In the verbiage I'm looking at, in the case of a standby guardianship, should file. Guardianship provide notice. Who's the guardian at that point in time if they're filing for the petition? Because the bill that proposes to establish standby guardianships for children whose parents have been subject to adverse immigration status, where does this all kick in here?
This kicks in after the guardian has been appointed. So this is, if you look at this section starts over back on page 12, this is the powers and duties of the guardian. So after a guardian's been appointed, this is what the duties are. So the phrase you're looking at, Senator North, is just saying, it's not about the timing of the appointment. It's just saying, hey, if it's all the preceding page and a half has to do with all guardianships for children in general. Those are the powers and duties. This is just saying also in the case of a standby guardianship, you could even, if you wanted, that you could read that as really saying granted pursuant to section 20, because it's after the guardian has been appointed.
Yeah, it's not like one card for the force here is all.
Yeah. But the intent is to be that after the guardian is appointed, here's another thing they have to do.
Okay.
And it adds that evidently so keeping the custodial parents and the attorney in the loop on various things, changes and status reports, which I'm not sure exactly what changes part is getting, kind of a broad, keep them up to date kind of thing.
So maybe we can find 15 minutes for Judge Stoney to come back in just to flesh this section out a bit more and make it a bit more specific rather than ambiguous. So, or are there any other suggestions? Moment or should we move on? So what I have on the next page.
Actually, I was going to suggest on that as well. It might also be worth, I don't know this for sure, but I'm guessing that I think that was part of the original proposal from legal aid. So I can email them or you can ask them. I'd be interested to see like, what is it that you guys are trying to get at?
Yeah, if you don't mind emailing legal aid, you can, that'd be great.
Yeah, sure. Well, let's
Clarify that a bit. Next suggestion. Concern I have is page 15. The top. Case of a standby guardianship established under the section of the Supreme Court shall accept filings that does not meet the format and signing requirements for the motion under appropriate rules 10 and 11. I guess the recommendation was that if there's good cause shown, the court can accept incorrect formats, but they otherwise do need correct information. Which I don't think is an unreasonable request, considering we're talking about placing kids with other people.
What was the rationale for this piece?
I believe the rationale being that if somebody is detained in a facility where it's very difficult to get access to an attorney, that parent may not be able, lay person isn't going to know that they need to go to the Vermont Rules of Program Procedure 10 and 11 to make sure the format's correct. And so formatting is a very particular process. So, yeah, I think that's the origin of the.
Because it sounds like they shall accept filings and the format and signing requirements are completely out the window.
Yeah.
Which is a little disconcerting.
Yeah.
Now, this is only this is only for a motion to terminate. It's not for the entire, I think that, as you're saying, it's an issue. And it's, I think I also envision they might be detained or they might be outside the country. And by that point, they may have been relocated to outside the country. And if that's that point, they want to terminate the guardianship and maybe have the kids returned to them where they are. So they can do that without meeting.
Yeah, I mean, my concern with me though is, if a kid's guardianship is going to be terminated, and I feel like you're going to want correct information if we're talking about sending a kid that was here to another country to be reunited with their parent, gonna want correct information as to what they're filing and who they are, their signature, the date, where they're filing it from. I think those are important.
What if we say this court may accept funds?
Yeah, the suggestion again was to incorporate for good cause shown, the court may accept filings that do not meet the format and signing requirements. I
That sounds good.
think it's sufficient.
I had written down incorporating what we're saying, it would strike shall, it would read the court may, comma, for good cause shown, comma, except filings that do not meet the. So it gives them the option to do what you're saying. If in a particular case, there's a reason to do it, but otherwise you got to meet the requirements.
Yeah, I think that works. Any thoughts? Those are all the notes that I have right now. Are there any other recommendations, suggestions, or concerns, comments? Thanks. All right, so yeah, we want to combine those two bills and get those changes, and we can revisit it sometime next week. We'll find the time or the week after that. We'll try to find an opportunity to have Judge Zellney come again, briefly to talk about that section. Before I forget, Caleb, would you mind letting Judge Zellney know
We're in early June.
about
September.
some of the confusion around that section? And if you could come in 15 minutes sometime next week.
Yeah, all right,
Well, there's a override session scheduled, actually sent out a notice.
What was the section I sent in that we wanted? Is it on that?
Yeah, go ahead, sorry.
Yeah, we did the light.
Maybe tonight.
What was the section again that I?
Yeah.
I just need to know.
Page
We're gonna
14,
pass it.
it's subsection D, I'm just for cancel.
Yeah,
Line E. Well,
so here's what
Oh, yeah.
I'm saying. I could see us getting out.
Yeah. You can ask
In
them
the middle of
to
the night, but then definitely
try again
some bills.
in 15 minutes.
Come back to the meeting.
Page 14.
I don't mind the education piece to be done.
We're just looking for more clarity.
May 9th, second, tentatively at 16th. Not being late.
Last year we got, I think I'm 16. So hard to imagine that all we got around being get up earlier.
So next up, we're going to have Ben come in. Did I say?
I think we said 2:45.
Let's take 5-minute break. 7.
that's all.